We're going to move on to the third type of secured transaction, mortgages. I like to talk about mortgages as separate from the secured transactions involving personal property. This is a secured transaction that involves the security of debt, with the security being real property. When people purchase real property, typically they're going to a financial institution and they're looking for a great deal of funds for a very long period of time. A mortgage is the written document that gives the creditor, and we call the creditor the mortgagee, an interest in or a lien on the debtors, and we call the debtor mortgagors, real property as a security for the debt. And I'm not going to go into the history of a mortgage, but it's been around, some version or some type of a mortgage. We call it a mortgage now. We didn't call it a mortgage back in the English land of the law way back when. But it has been around a very, very, very long time, because property way back when was associated with wealth. That's how people were distinguished. What we're going to talk about is the laws now. What governs the laws of mortgages now? We have state and local statutes. The states really dictate how things like foreclosures work and putting people on notice and so forth. So we have state and local laws that govern. We have that Truth in Lending Act, which we discussed already. We have the Equal Credit Opportunity Act, which we discussed already. Both of those are federal statutes. And then we have this new one we haven't talked about yet, the Real Estate Settlement Procedures Act. And this relates to federal government. It's related to federal government loans that secure residential properties. It applies, like I said, to federal loans securing residential property. It protects against abuse in the settlement negotiations of for the process of obtaining a loan, discrimination, things of that nature. And it's a disclosure act, and it's very similar to both, I should say, a combination of the Truth in Lending Act and the Fair Credit Reporting Act, in that they have to disclose certain types of rates and what it's going to cost to get this loan, and they can't discriminate in providing for the loan in any way. So, but I want to make the distinction between the two. The Truth in Lending Act and the Equal Credit Opportunity Act involve all sorts of creditors. Applies to everybody doing whatever kind of secured transaction. The Real Estate Settlement Procedures Act is strictly for government loans, federal loans, and it's for residential property, in securing residential property. It's very limited. And the group that oversees these types of loans is HUD. Maybe you've heard that term before. It's the U.S. Department of Housing and Urban Development Policies. Not policies, it polices. It's a department, and we refer to it in short as HUD. So let's talk about types of mortgages. We have fixed and adjustable rate mortgage, or for the short term, we call that ARM. The basic distinction, what's the difference? In a fixed, we have an unchanged interest amount, meaning that the debtor's monthly payment is going to remain the same for the duration of the loan. So we know what the fixed interest rate is, 3.5% for 30 years. And the mortgagor will know exactly what they are paying for the duration of the loan, which may be, in a typical real estate residential homes, 30 years. With our adjustable rate mortgage, or ARM, the rate of interest changes periodically. Typically it starts low for a fixed period of time, and then it raises over the course of the length of the loan. So for example, Bryan borrows $250,000 from Community Bank to finance the purchase of a house. The loan is an ARM. According to the terms, the initial interest rate is 3.75% for the first 3 years. Beginning the fourth year, the monthly payment is to be adjusted annually by adding up to 3 percentage points to the appropriate economy-wide index rate. So there's a couple things going here I want to point out, so I use this example. So we start with initial loan, 3.75% for the first 3 years, and that's pretty common. This would be pretty common start, 3 years at an initial interest rate, whatever that may be. It could be 2.75%. The rate is determined on what the economy-wide index rate is and compared to where you are locally, if you're in New York or if you're in Nevada or whatever. So then beginning the 4th year, that payment will adjust. And usually it's adjusted to go up, not go down. 3.75% is going to be the lowest. But they can only add up to 3 percentage points. That's a law, that's a rule. So you couldn't, on the 4th year, all of a sudden end up with a 12% interest rate. You would know that the highest it can go is 6.75%. That would be the cutoff, adding up to 3 percentage points. But it's also determined on the economy-wide index rate as well. Usually doesn't jump up that high that quickly, but that would be the cap off. And then we have our distinction between government and conventional loans. And when we're going to be talking about government loans, we're going to be talking about this is when the Real Estate Settlement Procedure Act will come into play. Those are the loans that they preside over or watch and make sure things are going okay. But let's start with the conventional loan. That is the most common. That's where you go into a bank, you want to get a loan for $100,000 for a house, you fill out the paperwork, you meet whatever requirements they need, and that's a typical type of a loan, conventional loan. The key is that the home loan is not insured by the government, meaning if you were to default on the loan, the government isn't going to come in and pay off the bank. I'm going to talk about insuring loans, home loans in a little while, but let's distinguish between the government loans and the conventional loans. So the key distinction is the government insured, and our government loans are insured by the government. We have 3 types. When I say they're insured, they're backed. The mortgages are backed by the government. If a mortgagor defaults, has one of these loans, the government can be on the hook to pay for the mortgage. So they're kind of backing the mortgagor. It's a lot harder to get one of these loans. There's certain requirements relative to those. The first one is the most general one, the Federal Housing Administration mortgage. And it's managed by HUD. It's available for anyone. Anyone can apply for this kind of loan as long as you're first time buying a house. And basically the government insures the lender against losses that might result from a default. One of the key advantages is a low down payment. Most of the time, and now since the 2008 bubble burst of the home loans, 20% is required. That used to be, there was some wiggle room there, but 99% of the time, if you're going in for a conventional loan, they want 20%. But on a government loan, under the FHA, an advantage is they can take as low a down payment as 3.5% of the loan. Disadvantages, however, they're going to require, if you're putting down a low interest and not a 20% interest, a 20% down payment, then you're probably going to be, a mortgagor will be required to pay what's called mortgage insurance, and that increases the monthly payment a bit. But I'm going to talk more specifically about mortgage insurance. But this type of loan is backed by the government. 2 other types of loans backed by the government is a VA loan. It's a U.S. Department of Veteran Affairs loan. You have to be a veteran. This offers a loan program to military service members and their families, and it's government insured. And the key advantage is that you can borrow the entire 100%. 100% financing is backed by the government. And no requirement for having insurance. So that's a good loan if you are a military personnel or former personnel. USDA loans, Department of Agriculture is responsible for these loans, and these it's a loan program offered to rural borrowers, farmers. You have to meet certain income requirements, and it is government backed. And that's all you really need to know about the difference between conventional loans and government loans. Now let's talk about the documents. What we need that makes up this transaction, we need a note, promissory note, and we need a mortgage. They make the deal. We have the mortgagor. They're the one that gets the loan. And they sign the note. And the note is the obligation that serves as a security. And then we have our mortgagee. The mortgagee gets the security interest. They get the mortgage, and the mortgage is evidencing the security interest in the real property. The mortgagor is required to sign both of these documents. The note itself, it's a form of commercial paper. We're going to talk about that when we talk about negotiable instruments. The mortgagor promises to pay the agreed upon amount with interest by a certain date. It's like an IOU, right? And loans and mortgages are usually 15, 20, and 30 years long. And that's like I said, that's the obligation that serves as the security interest of the mortgage, or the mortgage, i.e. our security agreement. A key component to a note is something called an acceleration clause. And what is that? That's a clause that allows the lender to seek collection of the entire amount due and owing. That includes the principal and the interest should the mortgagor default. And that means, when I say default, that means they miss a payment. You make one payment, you're automatically in default, okay? Why this clause? Why do we have this kind of clause? Because if that was not in the note, the lender wouldn't be able to foreclose the entire mortgage when there's a default. And they would have to wait until the expiration of the loan. That's the mortgage secures the real estate, and the real estate is assessed or appraised at a certain value. You miss one payment on a mortgage, maybe it's, $1,000. That's not the $1,000 is what you're behind, but that's not the entire debt amount. And in order for them to foreclose, they have to be able to exercise their right to get the entire amount so they can foreclose. So that's the acceleration clause, where they say you miss a payment upon your default, we're entitled to collect the entire principal and interest that's due and owing. So, but when they do this, the mortgagee has to act in a quote-unquote equitable and fair manner in executing the mortgage and when they're enforcing it. That seems to have some wiggle room there if you're familiar of anything that has gone on as a result of the 2008 bubble burst of the real estate market. There was a lot of interesting maneuvers and so forth. I'll talk a little bit about it when we talk about the foreclosure aspect. So the mortgage must be in writing. Why is that? Because it's a contract involving real property. The statute of frauds requires it. Does the note have to be in writing? Generally, a promissory note wouldn't have to be in writing, a promise to pay a debt that's owed, but because the mortgage itself will reference that note, the note will have to be in writing. And most of the time it's attached to the mortgage. And some of the things that the mortgage, well, not some, all of the things the mortgage must include, mortgage document, the warranties that the debtor says they will pay, the stated amount, the terms of the debt. There are some duties that the debtor, mortgagor, required. Taxes. You'll see something like you have to pay the taxes, and you have to pay the insurance, and you have to pay for any repairs, i.e. don't let the place go to ruins. Why is that? Because it would affect the value, affects the value of the property, and that means the assessment or the appraisal can go down. Then in turn, the amount that's secured is now a lot less. The security is worth a lot less than what's due and owing. So these things are required. You have to pay taxes and insurance and make repairs. And we'll talk about why it's important to pay your taxes in a second. So on Moodle, I have a sample mortgage. That is one that's used in New York State by a local credit union. It's 18 pages long. I know the book has a sample mortgage that's only one page. The one that's attached in Moodle is a much more thorough and what one would most likely see relative to a mortgage in New York. So other protections that are available to the creditor besides having the mortgage or the security interest is private mortgage insurance. That's what I was talking about earlier, or sometimes just mortgage insurance, but for short they call it PMI. And this requires the debtor, if they don't make a full down payment, like I said earlier, since 2008, it's really almost mandatory. You have to have 20% down. But in some instances, like the FHA loan, where it's not required, mortgage insurance could be required. So here's an example. After providing a $10,000 payment, Maria borrows $190,000 from Northwest Timber Bank to buy a house worth $200,000. She only made a 5% down payment. So the bank is requiring, in my example, the bank is requiring her to obtain PMI. Who would be the beneficiary? Not Maria. Maria would have to name the bank as the beneficiary, because in the event that Maria defaults, what can the bank do? Exercise their right to be the beneficiary on that insurance or pay for any default. So that's how the private mortgage insurance works. And then there's two other types of provisions that protect creditors. We have a prepayment penalty clause. The prepayment penalty clause is there's a penalty if a mortgagor pays off the full mortgage before the mortgage note comes to full term. Say the term is 30 years and in 10 years they pay it off. Sometimes there's a prepayment. Most of the time in conventional loans there's not, but sometimes there is, and the purpose is, like an example would be refinancing within 3 years. The interest is front loaded, kind of like when you buy a car. So the bank is kind of securing their profit of what they would have made on you had the mortgage gone to the full 30 years. So they have a prepayment penalty, some percentage depending on when it's sold, if it's sold prior to the full term. But that's a rarity. There's a requirement that you maintain homeowners insurance. I just talked about that one on the last slide, but that, like I said, protects their interest. And recording the mortgage, it's an additional protection. But I'm going to talk more about recording the mortgage when we talk about the priorities, which is the next slide coming up. Priorities and recording. Recording is when the lender files the note and mortgage with the government county office where the property is located. So if you own property in the city of Plattsburgh or the town of Plattsburgh, you're in the county of Clinton, which means the county clerk's office is going to be where any note and mortgage regarding that property will be filed. And this is very similar to our secured transactions. We talked about perfection. Same concept, except it's called recording. And what it does is it creates the priority in the collateral, meaning it's first come, first served, right? First dibs in the event that there's another secured party that has an interest in that particular property. Because if it's not recorded, what can happen? They stand to lose their interest in that property. So we have that same concept relative to mortgages, but we call it recording. With secured transactions, we call it perfection. With mortgages, we call it priorities. It's kind of like putting people on notice that it exists. And you can, when it's recorded, it's a public record, so you can go down and look and see if there's any other secured parties or creditors attached to that property. So a mortgagor signs a note and a mortgage for $100,000 for a 30-year loan from credit union. The credit union does not record it. 2 years later, mortgagor takes out a home equity loan against the home for $50,000 and securing that loan with a mortgage against the property. And it's a 10-year loan from local bank. The local bank records the mortgage. 2 years later, after that, the mortgagor defaults on both loans. And the question is, who can bring legal action against the mortgagor? Well, both of them certainly could. Both of them can start a foreclosure proceeding or a proceeding to attempt to collect the debt. But who would get paid first? The first to record. So the holder of the home equity, which came after the fact, is going to be ahead of the mortgagor, the credit union, mortgagee, credit union, with regards to this issue. So they'll get to collect their $50,000 or what's left of the $50,000 before the credit union will be able to collect the $100,000 or whatever's left of the $100,000. So that's why it is important to record. If the credit union recorded, then the home equity lender, the local bank, would have known because it would have been recorded and there would have been notice. And they may have decided not to give the loan for $50,000, or maybe did, but then they would be secondary in line behind the credit union. This also would, if the credit union didn't record their mortgage and there was someone who subsequently bought the property, when someone normally when somebody buys a piece of property, they're going to look to see if there's any lien or attachment to it, anything recorded against it, and if it's not recorded, they're going to be able to take that free and clear, the subsequent purchaser of a property. So it's very important to record. But there are some exceptions. There's always some exceptions to the rules, right? When we're talking about a purchase, money, security, interest, and fixtures, I kind of did not glossed over it when we were talking about it under secured transactions, and here's why. What is a fixture? We talked about fixtures when we were talking about the different collaterals and definitions. Fixtures are things that become as one with real estate. Windows, plumbing, furnace, things that are ultimately almost attached to real estate. And removing them would affect any value of that real estate. So when we have a purchase, money, interest, security interest, and fixtures, they will take priority over a recorded mortgage, or definitely not a recorded mortgage, but a recorded mortgage, if the security interest was for goods before they became fixtures, or 20 days after the filing, meaning they became fixtures 20 days after the filing. What would be the reason for this? Just like I said, the fixtures now become part of the real estate, and that kind of adds value to the bank's secured interest. So let's take this example. Susan buys a new furnace for her home from heating company. Susan gave bank a 30-year mortgage on the house 10 years before. Heating company takes a security interest in the furnace and perfects it before it's installed. So what happens if she defaults? Well, the heating company would have priority because our furnace was a good before it became a fixture. And the security interest was filed before it was installed. So it was filed when it was a good, and then it was installed. Would it make sense for the heating company to just come in and take their furnace? No, because now it's going to affect the security interest in the mortgage. So that's why we have something such as this where the fixtures would take priority. Tax liens. Once the government assesses a tax, the amount constitutes a lien on owner's property, real or personal. Until it's filed, though, it doesn't really have much weight. It's just kind of there. Doesn't have any weight, doesn't have any priority over creditors, even though once it's assessed, the amount constitutes a lien. However, once they file, and, well, let me give you the rule. Once it's filed, they take top priority. And if it's for the federal government, they have to file what's called a notice of federal tax lien. It's a public document, and it's filed in the county where the resident who owes the taxes resides. For New York State, there is a New York State website if you have New York State taxes, and I have a link to it on Moodle. You can check it out where you can search parties' names for tax liens. They have a website for warrants of tax liens where they do the filing. But once filed, taxes take priority. There are some limitations on collecting awards from people's workers' comp or unemployment or to support minors, but for personal property, because that's what we're talking about, we're talking about real estate property, they will take top priority over a mortgage, over our fixtures lien, over our mechanics lien, which we're going to talk about next. They get top priority. And local governments, they assess liens on property taxes, and if you don't pay your property taxes, they get to assess the lien. There's usually a 3-year, in New York State, there's a 3-year window before they can even foreclose, so you have like 3 years to catch up. But they are top priority. Taxes, top. Mechanics liens. This is the most common type of lien. It's obtained by one who furnishes labor, materials, or services on real property. We talked a little bit about that when we talked about secured transactions in comparison with the artisan's lien for personal property. It's statutory law, so it's different from state to state. In New York, you have to file. In New York, yes, you have to file within 90 days of completing your work, and you have 1 year from the filing to bring some sort of action, which is usually a foreclosure action. You can request an additional extension 30 days before your first year runs out. The court will have to determine whether or not your lien is valid, whether the type of work is the type of work that the lien is used for, whether you filed it properly, whether it's filled out properly. So a court will determine whether or not your lien is actually proper before they allow you to foreclose and take the property to sell it to get paid. The difference, just to step back, we have our fixture filing and we have our mechanics lien. Both of these have priorities over a mortgage, not over the taxes, but over a recorded mortgage. The question is which one of those takes priority over each other. That's when the first in time, whoever's there first, it's the first in time rule. So if there's a fixture lien and a mechanics lien, the fixture lien was filed before the mechanics lien, it'll be the fixture lien, the mechanics lien, the mortgage. If there's also a tax lien, that's going to be at the top of the chain. And now we have, I just want to stick a note here since I'm working through the chain, judicial liens, they are always at the bottom of the food chain. So if there was a judgment that was obtained against you in a court of law, that is going to be behind everyone who has recorded. If nobody's recorded, then it's going to be prior to any recording. So let's say our mortgagee didn't record, and we have a fixtures lien, we have a tax lien, fixtures lien, a mechanics lien, then a judicial lien, and then the mortgage company goes, oops, wait, we didn't record, and then they record, they're going to be at the bottom of the food chain. So recording is important. Termination, how does a mortgage terminate? 3 ways: payment, assumption, and foreclosure. Payment's nice and easy. That's when the note is paid in full. The mortgage is discharged. So 3 ways that happens: you sell the house and you pay it off, or you just pay it off completely and you remain living there, or a refi. Maybe you go to a different lender who's got a better rate and you do a refinance, or maybe you've had your loan for 20 years and the bank has better rates now and you refi. You do a refinance, you pay off the other loan and you start a new loan. But once payment has been made in full satisfaction, then a document called a satisfaction of the mortgage gets filed, and that will be that tells people that this mortgage that was recorded has been satisfied. And then we have assumption. They have a nice little chart in the book with regards to assumption. But this is when property is sold without paying off the mortgage. We have 2 ways that this happens. We have a new buyer comes in and assumes the mortgage, which means they agree to pay the seller's debt. That's part of the taking it over or assuming it. And if the bank agrees to allow that to happen, then what happens is they release the old mortgagor, or the seller, and substitutes the new buyer on the mortgage. We call that a novation. But everyone has to agree. And then we have the new buyer who does not assume the mortgage, or they don't agree to pay for it. And they take the property, quote unquote, subject to the mortgage. And we had this concept of subject to when we were talking about secured transactions. But what this means, though, if you have a buyer that does not agree to pay the mortgage or assume the mortgage, and they're taking it subject to, in the event the seller defaults on the mortgage, the mortgagee can come and take the property. So it's pretty important that the buyer makes sure that the seller pays for the property. Otherwise, the mortgagee holding the mortgage can foreclose. But the buyer wouldn't be responsible for anything over and above that's due and owing. We call that a deficiency. I'll talk about that when we're talking about foreclosure. But make sure you distinguish between the two. So, for example, Abe bought a duplex from Carr, who had borrowed from First Bank for its purchase. Abel took title subject to Carr's mortgage. Abel did not make mortgage payments to First Bank. The bank foreclosed and sold the property, leaving a deficiency. Which term is correct? So which one of these is correct? It would be number 1. Carr alone is liable for any deficiency. Do you see why? Because Abel took title subject to Carr's mortgage. That was the number 2 example above. So even though, and I also say that Abel did not make any mortgage payments to First Bank. He's not required to. Carr is. So if the bank forecloses, and he takes the property from Abel and sells the property, leaving a deficiency, which one is correct? Carr alone is liable for the deficiency. He did not assume the mortgage, he took it subject to. And the First Bank cannot pursue both of them. And in the event that Carr still fails to pay, Abel won't be liable. Due on sale clause. We have this kind of clause. Well, let me tell you what it is. It requires the entire mortgage amount to be paid if the property is sold. This is where mortgagees protect themselves from assumption. They don't particularly like assumption. From what I understand, I don't believe it even happens nowadays. They just want to be, mortgagees want to be paid off in full, and they want a nice clean mortgage with another person. It also prevents the ability to get someone. The purpose of this clause is to prevent the ability to get someone on a higher interest rate, right? So let's say I have my house, I've had it for 10 years, and I have an interest rate of 3%, but I want to sell my house, and currently the rate is 6%. You might want to, make an arrangement where they assume the mortgage. So somebody doesn't get a higher, if they have to go out and get a loan, they're going to pay at 6%. The bank doesn't want that to happen. They want to prevent assumption. They want to get paid at 6%. So they put these clauses in, due on sale clauses, meaning if you're going to sell this property, you have to pay it off, or you're going to be in breach. And then they can come and foreclose despite the assumption. So they're trying to prevent assumptions. But in the event that they do agree, they call that a novation, and that was the number 1 example above. And I didn't know, even families, they don't even like families to take over. So if you have a husband and a wife who bought a house together, and then they are divorcing, and one of them wants to take over the mortgage, mortgage companies require them to do a refi and remove the other individual's name. All right, foreclosures. That's the legal proceeding in which a mortgagee takes title to or forces the sale of the mortgagor's property to satisfy a debt. I will note that the book, and several of the books that I've been reviewing for this class, use the term repossess. It gives the mortgagee a right to repossess the property. That is not accurate because, as we talked about repossessing, you don't need the court intervention. Let's say we're repossessing a secured transaction or a car. They can just go and take the car. They don't have to do anything else. They'll except send a letter saying, if you don't pay us, we're going to come and take the car. That can just happen. That cannot happen with real estate. There has to be court intervention. So there has to be a foreclosure, a legal proceeding. The mortgagee just can't come in and toss you out. So what is the mortgagee seeking in a foreclosure? The purpose is to ask the court to give the lender title and possession so that it can sell, because who's holding the title is the mortgagor. So they need to get the title, and that's what they're asking the court for, is give us title, and then there's a settlement or a selling process. And the process goes something like this, and I'm using New York as an example, but this is pretty much standard. There is a pre-foreclosure mitigation review period, and I will tell you this came into play, I believe, right after the 2008 issue. And this is a federal rule, and a mortgagee cannot bring a foreclosure action until the mortgagor is 120 days delinquent. So there's I guess that would be a 4-month period before any legal action can start. There's a requirement. It's usually in the note, but there's usually a contract that says the mortgagee has to send a letter to the mortgagor saying, notice of default, here's the amount due, here's how you fix this problem or cure the problem, and you'd be facing legal action. In New York State, and this was always in play, and I'll show you how it works with number 1, but number 3 is a 90-day notice. There has to be a 90-day notice before starting any legal action. So 90 days prior to them wanting to institute a foreclosure action, they have to say, we plan on starting a foreclosure action. And this runs at the same time, concurrently, with the 120-day period set forth in the federal rule. And then there's the lawsuit. The lawsuit starts with the lender filing a complaint. They serve it on the mortgagor. The mortgagor has 20 days to respond. The court might hold a conference or two and then have a hearing. And during the hearing, the bank who wants the property has to show proof. They have to show proof that they hold the loan and that the mortgagor, who is the one who is responsible for the debt, and that person defaulted. And this is where a lot of foreclosure actions stalled out, 2009, 2010, and still to this day. There's crazy long foreclosures still going on in this county, is with the assignment of the notes. This is what happened is, you go in to your local bank to get a loan, and then they sell it off, to Bank of America. And then Bank of America assigns it off to somebody else, and they couldn't keep track of the food chain of who did the assignment when, and was the mortgagor giving notice, and that's what hung up a lot of these cases. So they have to make sure their T's are crossed and their I's are dotted. And once that happens, if the court feels that is official, then they'll give them title. They will also court appoint somebody called a referee, and that's somebody who handles the judicial sale. They'll make sure it goes according to the law, that there's certain postings and notices that have to be given, especially to the mortgagor, and how the proceeds will be distributed. Usually it goes to the highest bidder, but most of the time the lender needs a certain amount to make their debt, so usually they're coming in and buying it. But nonetheless, it goes to the highest bidder. Now, what if you don't show up to court? What if you got served with the paperwork that a lawsuit has begun and you don't show up or respond? You'll be treated in default, and the court proceeding will go forward without you. and the court will usually give the bank what they are asking for. All right, number 6. So after the judicial sale, then there's an eviction process. If the mortgagor is still living there, there's a 10-day notice to vacate the property. If not, the sheriff comes and removes you. So there was something in the book called a power of sale. That's not an option. That does not exist in New York State. So that's something that you don't need to know. And then